This week on In Business Las Vegas, double-digit gains make a return appearance on the Strip. Is it the best sign yet of economic recovery?
Plus, a Nevada lawmaker bucks the trend and proposes a corporate business tax. We'll have the details.
And is this town big enough for 2 mob museums? We'll hear from the man in charge of the downtown venture in Business Las Vegas. Next.
Dana Gentry and Jeff Gillen take a look at Nevada's movers and shakers. This is In Business Las Vegas.
And the state is fining a Henderson couple $10,000 for posing as mortgage brokers. The Division of Mortgage Lending says Raphael and Yvonne Chacon never had a license and never asked for a hearing after the complaint was filed against them last month. The complaint says the two solicited $25,000 from an investor to make a loan on a second deed of trust, but the Chacons never loaned the money and never recorded the note. Some Nevada attorneys claim the state's foreclosure mediation process is fraught with bias. This week, the state Supreme Court held a public hearing on proposed changes to rules for foreclosure mediations. It's the 5th time the court has considered changes since the law went into effect a year and a half ago. The final iteration of those reforms has yet to be announced. Joining me to talk about what to expect, Damian Falcone of Falcon Credit. Thanks for being here. Now, you attended that hearing.
Yes, I did.
So what was the biggest complaint that you heard?
The one that got the most action was whether mediators are going to be allowed to represent both homeowners and mediate.
What's the conflict there?
Banks' representatives are claiming that there is a conflict in mediators are privy to privileged information during a mediation where they're the mediator, that when they're representing a client, they can use that information against the bank.
In some cases, these same attorneys who are acting as mediators have litigation against the banks in their private practice. Is that the problem?
It appeared to me that the private practice of the mediator is in representing homeowners at mediation, and they tend to make good arguments, and the bank's representatives are looking to limit them.
Okay. I want to show our viewers what some of the proposed rule changes are. Expand the controls over mediators who do not comply with the program requirements. What was that all about?
Basically, the mediation program is the model for the entire country. They've been invited to the White House, and they've put it together very well in a very short period of time. But in a normal process, you put out the rules, and then the next logical step would be violations to those rules. So in the event a mediator would deviate, or if there were situations that weren't exactly covered that would require inference by a mediator, they've been clear as to consequences to inferences made.
What about, was there any discussion of judges not complying with the law? We've done stories about Judge Donald Mosley, who gets the foreclosure cases in Clark County, refusing to impose the ultimate sanction, which would be a bench-ordered modification. And now I know that case is going to the Supreme Court on appeal. So were they able to discuss that?
Judge Mosley didn't come up too much, no.
Okay. One other thing I want to talk to you about, let's see, they would further define conflicts that would disqualify mediators. We've already discussed that. It further defines the lender entities eligible to participate in mediations. That is just about who is actually eligible to come to the table and act on behalf of the bank. Is that it?
As far as I know, the lender representation is the same as it was before. It's the homeowner representation, which was a result of there are rules regarding who can represent a homeowner.
Which brings us to our last point.
Oh,
that
okay.
Prohibits persons who obtain powers of attorney from representing homeowners from receiving compensation.
Correct. And what my experience has been is mediators have told me that unlicensed people offering services to homeowners have gone to mediation with a homeowner. The mediator has felt that it would possibly be damaging to the homeowner to tell that person, you are not licensed, you are not allowed to represent this person. But the Supreme Court made an amendment that says that you in fact do need to be licensed, which is what they said before, and they just clarified it.
And that's to preserve the standing of people like you who did go and get licensed.
Yes.
Okay.
Yes.
And one of the problems with that is that, you know, when would you suggest that a homeowner go actually to somebody like yourself rather than just try to do it on their own with the bank?
Well, I recommend people always have a loss mitigation plan in place, whether they're experiencing financial hardship or not. So understanding the financial mediation or the foreclosure mediation program is, I think it's the most underused loss mitigation option presently being used. It's very beneficial. What the lenders claim of being very biased to the homeowner, they may have some claims there. I think the homeowners have a lot of great possibilities, and they should know more about it. When should they contact somebody? Like I said, having a loss mitigation plan in place is something everybody should do from a financially responsible perspective. But if you start missing mortgage payments, if you're upside down a few $100,000s on your house, these are very logical questions you should answer.
We are out of time. Thanks for being here, and we'll look forward to the rules coming out. Jeff?
All right, Dana, thank you. When in business.